What's up, everybody? Welcome to Understand America. Today we are going to learn about the Ghost Gun Supreme Court decision. We need to understand what kind of challenge this is and how a regulation is different than a law. A statute is the fancy word for a law. When Congress writes a bunch of laws and then they pass them, those are referred to as statutes once they're passed. And the ATF is an executive branch agency. And if you're an executive branch agency, one of the things you can do is you can put what's called a regulation onto things. They're rules that people must follow because those rules are in line with the statute. Ghost gun manufacturers in this Supreme Court case are claiming that the ATF put in regulations that are facially inconsistent with the statute. There are two kinds of challenges we need to understand: a facial challenge and an as-applied challenge. A facial challenge is exactly what it sounds like. If you were to read the statute on its face, you would go, oh yeah, the agency can't do that. That's not even what this statute's talking about. The Supreme Court has a specific test. It has to be a situation where there is no circumstance where this regulation is applicable. An as-applied challenge is saying, in this specific case, this specific ghost gun manufacturer's product is being improperly regulated. Meaning the Supreme Court would have to go through and come up with a whole slew of tests to say, well, this is the guideline we're going to start using to evaluate if a ghost gun is fair game for regulation or can't be regulated. This specific case does not do any as-applied challenges. It's a facial challenge. All the government has to show is that there are some instances where the ghost guns they're trying to regulate fit into the statute pretty well. Let's look at this statute. In the criminal title of U.S. Code, section 921A3, the term firearm means A, any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. B, the frame or receiver of any such weapon. C, any firearm muffler or firearm silencer. And D, any destructive device. They further go on in section 921A4 to define destructive devices to include component parts which may readily be converted into a destructive device. The specific ghost gun kit that the ATF brought to the forefront is Polymer 80's Buy, Build, Shoot kit. The majority opinion. The majority of the Supreme Court compared this kit to a starter gun. You know the guns that they shoot at track meets, and then everybody starts running? And with a little bit of knowledge, you can change a starter gun into a real gun. That seems to be a fair comparison. If it's just as easy or easier to change this Buy, Build, Shoot kit into an operable firearm as it is to change a starter gun into a real gun, then it makes sense to regulate this Buy, Build, Shoot kit as a real gun because starter guns are regulated as real guns. They admit that their reasoning here has its limits. They have an example. If you start with a heap of sand and then you start taking 1 grain of sand away at a time, eventually, there is not a heap of sand there. But where exactly is the line where we say this is a heap of sand and that is not a heap of sand is a really, really hard line to draw. So the Supreme Court decides not to draw one. They go back to their facial challenge stance and say, look, we're not drawing that line today, but because this is a facial challenge and Polymer 80 is out here selling a buy, build, shoot kit that takes less time than it does to convert a starter gun into a real gun, we're gonna go ahead and say that the buy, build, shoot kit can be regulated. And if one can be regulated, then the facial challenge falls away and it's deemed fair game for the ATF to regulate. Let's go over how the buy, build, shoot kit is set up and how close it is to a real operable gun. This is my gun. It's unloaded, okay? You can see. In Part B, the statute talks about the frame or receiver of a gun. A receiver is for like ARs and AKs and stuff like that. It's a little bit bigger. It's what you would know as the lower half or the bottom half of an assault rifle. This is the frame, different word, but same exact meaning, the bottom half of a handgun. Polymer 80's buy, build, shoot kit has two little tabs put in right here and right here, okay? Those two tabs, they're plastic. They stick up probably 1/4 of an inch. And they make it so that you can't just slide the top half on the gun and then use it. So the Supreme Court asked this question. If I had two extra little tabs that prevented me from putting my top half of my gun on this frame, and all I have to do is take some scissors and snip those two tabs, is this a frame? The majority said yes, just like an IKEA table that's in a bunch of little parts yet to be assembled. You would call that a table. That seems fair. It is a table, and it's actually not that far away from being a table. An hour or two of screwing some stuff together, and voila, you got a table. So if I cut two little pieces off and it takes me 5 minutes, that's a frame. There's nothing else you're going to mistake this for, right? It's not a hammer. It's not anything other than the lower half of a handgun. So to put two little tabs on top of it and pretend it's not a frame seems silly. But you could imagine if I took apart all these little pieces. You see there's metal pieces in here. There's a spring up in there. I have a trigger right here. If I took all of that out and it was just this kind of empty piece of plastic in the shape of the bottom half of a gun, is that a firearm we can regulate? Maybe. But the Supreme Court doesn't even try to define it that specifically. They don't need to, because this is a facial challenge. You could make an argument that, if I take enough out of this, it's not a frame. But the minimal amount that Polymer 80's buy, build, shoot kit did to make this not be a frame wasn't enough for the Supreme Court. The dissent, Justice Thomas and Justice Alito, argue that this, if I put two little tabs in here, that it's not a frame and that it shouldn't be regulated as a firearm because just this lower half is regulated as a firearm. And they say, look, if it's not operable, then it's not a firearm. Cut and dry, end of story. And they do that for two reasons. The first reason is in section 921 with a destructive device or a firearm. Both of those had a clause in there of may readily be converted to. However, subsection B, which covers this frame or a receiver, it doesn't have that or may readily be converted clause. And they argue that therefore, this with two extra little tabs, not operable, and therefore not a frame or a receiver. Which seems like a fair argument, right? If it doesn't work, and Congress was very specific, right? We assume Congress takes a lot of time to think about what law they're passing and how they're going to write it out just so. There's a direct quote, "We assume Congress says what they mean and mean what they say." And they didn't say anything about an inoperable lower half. The other reason that the dissent gives is this. If Congress can pass a law and then the ATF can go so out of their way to regulate any receiver or frame that can be converted into something else, then we run into this problem where ARs and AKs, which regular Americans own perfectly legally, they can be converted into a fully automatic AK or AR with just a simple little change of machinery on the inside, and therefore they may readily be converted into a fully automatic machine gun, which is illegal in the United States. Regular people cannot just have fully automatic machine guns. Then we're just creating a situation where the ATF can regulate a large portion of Americans into felony level criminals simply because they own a lower half that may readily be converted into a fully automatic firearm. The majority disagrees. The majority says, look, you're reading way too far into this. We haven't even given a proper line where a frame or receiver is a firearm. And as a matter of fact, if you were to read 921 subsection B, it doesn't just say frame or receiver. It says the frame or receiver of any such weapon, incorporating subsection A into subsection B. Remember 9th grade algebra, where they would make you substitute, you'd have like two equations where y equaled something, and then you'd plug in the second equation for y. The majority is doing exactly that. They're including that may readily be converted into in the frame or receiver. And look, if all I had to do was take some scissors and snip off two little tabs right here, I don't know how much closer you can get to may readily be converted into a firearm, into a frame or a receiver. So there's a couple of questions that are left to ask. One, are ghost guns banned? No. If you're a ghost gun lover, don't get your knickers in a twist. Ghost guns are still technically legal. Just the ones that are really, really, really easy to turn from a couple of component parts into a gun, those are going to be heavily regulated. But if it's sufficiently difficult that it may be converted, but may not readily be converted into a firearm, then those ghost guns are probably okay. So imagine it takes you 4 hours to put together instead of 30 minutes. Those ghost guns, they might survive. 2, what can ghost gun manufacturers do? Well, they could just put serial numbers on all of their ghost guns and run background checks, and they would probably be okay. But given that that's the whole purpose of a ghost gun is to not have to run the background check, what they're probably going to need to do is simply make it more difficult to build one. The other thing manufacturers can do is they can file that other kind of lawsuit. Remember, this is a facial challenge. Our other option is an as-applied challenge. So if the ATF starts going hog wild and they decide that they're going to regulate every single ghost gun and try to get them out of existence, then ghost gun manufacturers could do an as-applied challenge and say, look, my specific ghost gun is fine. It doesn't meet any of the criteria of a firearm. It's an art project. Whatever people decide to do, that's got nothing to do with me. I just sell component parts. They could reasonably make that argument, but they would need to do it in an as-applied manner, not a facial manner.